Alright, Title 2, General Procedure, Chapter 3, Council Actions. Introduction. The Council has considered all the information reports submitted with the result of the accreditation process that makes the judgment of the institution compliant with the accreditation criteria. The Council decision based on the extent of the institution compliant with the judgment may be referred to as the Council action, the action for which the Council may take with described in the chapter the procedure of the available to the institution general with the action for the maximum time frame for the achievement of the final disposition of the action by the Council whether examined or explained. The four general areas of the Council action with accreditation granted with accreditation deferred, accreditation denied, accreditation withdrawn. In conflict with the institution not in compliance with the accreditation criteria, they will take with the prompted virus action that against the institution will require the institution to take appropriate action to bring in itself with the compliance with the accreditation criteria within the time frame specified by the Council after the institution has been notified of not compliant with the time frame not exceed may less than the following 12 months. The longest program is less than 1 year long. 12 months if the longest program is less than 1 year long program. 18 months if the longest program is less than 1 year but less than 2 years in length. At least 1 year, but less than 2 years in length. 2 years if the longest program is 2 years in length. The approval of the above time may extend with the sole discretion of the Council for the good cause, including the evidence that there will be significantly improved the deficiency area of the applicable time of the frame, but it does not provide with the sufficient demonstration of the full compliance, significant improvement, completion of the placement rates, and in no event with the good cause the extension of the exam 1 year. 2, 3, 100. Accreditation granted. An institution found with the compliance with the accreditation criteria with the Accreditation Council independent college schools may grant with accreditation for the specified time of the minimum of 1 year with the maximum 6 years with the length of the grant shall be at the discretion of the Accreditation Council independent college school with the grading of the accreditation for at least 6 years but is not negative action, therefore is not appealable. The Council will not grant accreditation for this full 6-year term if the grant is awarded following any of the hearing resulting in the previous action denying accreditation. 2, 200. Accreditation deferred and conditioned. The Council, upon review of the relevant information concerning the institution, may take any of the following council and tying in accordance with the procedure described up and including with the final adverse action 2, 3, 210. Deferral. The Council determined the insufficient evidence available to make the decision makes the deferring action until the later date of the bond, pending receipt of additional information. In such a case, for the Council provided with the writing of the reason for the deferred state within the institution may need to provide significant time from the institution to respond with specify the responsible database for the nature of the number of the identified deficiency. But the Council may require attention for the key administrator of the workshop of the consolidation deferrals affect no action from the time of the negative action. Therefore, deferral is not applicable to the action either denial final section action in any all case of deferred renewal of accreditation or accredited council institution. Accredited institution, the Council will extend with the President grant of the accreditation period of the sufficient to the institution provided with the information needed. 23220. Compliance with the warning. The compliance with the determined the institution not compliant with the accreditation criteria of the Council may issue the compliance with the warning with the institution provided with the writing within the area of the non-compliance will require with the demonstrate the corrective action for review of the accreditation council independent council schools. And the Council may issue with the showcase the directive of the denial action with the result of the reviewing the compliance warning described in section 23230 and 23402 with the following report with the compliance warning with the institution must bring the result from compliance with the time frame specified in Title 2, Chapter 3 of the institutional subject of the final adverse action. 23230. Show the cause of the directive. The show cause is staff of the Council may impose the institution when it is determined the institution does not materially operate in accordance with the accreditation criteria. The Council will provide with the institution written summary of the areas non-compliance. The institution will require to provide evidence for the corrective action for the review of the Accreditation Council independent college and schools following the receipt of the showcase of the directive. The institution must bring with itself in the compliance with the time of the flow ran specified in Title 2, Chapter 3 for the institution will subject with adverse action. The issuance of the showcase directive may be considered with the basis for the hearing. The discretion of the Council was defined in Section 23500, but the suspension order for the denial action may be issued by the Accreditation Council and independent college and schools to resolve this hearing. Such action considered with the final action which may only be appealed to the Review Board of Appeals described in Section 23600. All institutions issued with the showcase of the directive of the Council will be the director to submit the school closure plan may be required to submit the teach-out agreement is described in Section 22303. Accreditation criteria. Result of the showcase: the Council shall not accept the application for the new program, the new campuses for any of the institution showcased unless the institution receives approval of the evidence and to submit each of the application 232 vacate showcase. The institution demonstrate the address for the Council concerning its operating compliant with the Accreditation Council. For the Accreditation Council, independent college schools may vacate the showcase for the Council may also order the special visit with the institution on expense before limiting of the showcase. 23233 notification of showcase. The council shall notify the U.S. Secretary of the Education appropriate state of the regulatory agent for the appropriate accreditation agency public health with the decision that you place for the institution on the showcase of the institution required to notify immediately with the current with the prospective students along with the public showcase staff through the appropriate means, including posting a prominent notice on the website. 23300 accreditation denial. The denial of accreditation status for the characterized by the council is withholding action, the differential from the suspension of accreditation with withdrawal and action. There are two levels of denial. Only two withholds of the accreditation institution or a branch of the order denies approval of the required substantial change. The denial at each of the levels to constitute the negative action changeable by institution. The process channel, however, different each of the levels of denial separately described in section 23301, 23302, and 23303. And the all cases of denial of the change. The council will give the institution written reason for denial, which are subject to modification through the appeal of the process later described and explained. Denial action that are not applied within accordance with the appeals procedure provided with the council or considered the final action. 23301 denial initial grant. The institution objects to the council decision for the denial application for the initial grant. Accreditation has the right and will be given the opportunity to present in case to be heard by a panel of the review board appeals. In such hearing, the institution may not present new evidence for the consideration must follow the procedures described in section 23600. Denial of renewal accreditation change with the ownership and control and instruction of the object of the council described in the denial of the application for renewal of the accreditation reinstatement of the accreditation following the change of ownership of the control have the right to appeal with the decision review board appeals pursuant to the procedure that's described in section 23604. Additional denial of the renewal accreditation reinstatement of the accreditation following the change of the ownership and control of the council may establish showcase the directive as described in statute section 23230. 23303 for the other denial actions not affecting overall accreditation institutional object for the council to deny a decision to deny the application of the branch to freestanding the staff of the new program in its conclusion will be given the opportunity to present any case of the panel with the council to be heard with the subsequent regular schedule of the meeting. The council of the institution may offer the new evidence will consider with the council and timely submitted with the 23304. The subsequent action following the denial, and if denial not affecting the overall accreditation is affirmed, but the denial action must become the final, and no other final or further remedy is available to the institution. In all cases of denial, the council will retain the discretion to decide whether under what conditions the institution may initiate the request for the consideration of the same type of application. Alright, 23400 accreditation withdrawal. Withdrawal of the accreditation differs with a different denial of the accreditation. The denial rejects the institution for the application for the initial grant of the accreditation for the renewal of the accreditation to effect upon the expiration existing grant accreditation. Withdrawing accreditation takes away current grant accreditation before the expiration. Accreditation may be withdrawn with the institution through two types of council's action: revocation or of accreditation and suspension of accreditation. Revocation occurs without a hearing for any of the following reasons. An institution notified the council that it is closed to receive the operation. An institution whose accreditation has been summarily suspended but does not change with the suspension within 10 days of the receipt of the suspension notice. Institution fails to file an annual report required by the council section 21801 21802. Institution fails to pay in annual fees, application fees, other assessed fees, and evaluation expenses section 21804. As a revocation action not applicable that requires the institution to start anew undergoing entire accreditation process, regaining accreditation 23402. Suspension for the accreditation may occur within the judgment of the Accreditation Council of Independent College Schools that any institution no longer complied with the criteria by the line. By way of illustration, Accreditation Council of Independent College Schools may issue the order of suspension for the region for the following institution of any of the components of the ranch new program. For example, the evaluated with the director of the Accreditation Council of Independent College Schools that determined not in compliance with the criteria. Periodic reports filed, but the institution failed to conform with the compliance council reporting requirements. The institution might make substantial, significant change without accreditation Council of Independent College Schools in its operation, structure, governance, ownership, control, location, facility, and program of study. The institution fails to respond to cooperate with the attempts by the council to make arrangements for the site evaluation. Institution has deviated with the criteria of the other directives of Accreditation Council of Independent College Schools. Institution fails to disclose the arrangement option for the other contractual arrangements between the institution and other parties with the bear management with control of the main campus and the non-main campuses. In all cases, suspension of the council retained with the discretion to specify whether under the conditions that the institution may apply with the initial grant accreditation. 23403 procedural with the grant with the withdrawal with the suspension. Okay, with the accreditation subject to the withdrawal of the suspension under the section 23402 with the institution afforded with the following procedural grants. The opportunity for the hearing of the credit before the Accreditation Council, independent colleges and schools are only on all materials issued with the controversy written prior note with proceeding the change charge levied and standard with which is the institution ultimately to be judged. The decision on the record alone with the statement of the reason for the ultimate decision, right of appeal provided by the section 23600. A review board of appeals affirmed that the withdrawal of accreditation by the way of the suspension of the appeals shall be deemed with the final disposed upon the issuances of the decision for publication which is made described in section 23607. Alright, counsel hearing procedure 23500. All hearings of the principal, all hearings with the reading unless for the counsel exercise with the sole discretion to allow the hearing of the person before the counsel for the following procedure will be given in the hearings to held before the council. Exception for the hearing must be made with the date determined by the council, which will not be less than 10 days of the day of the receipt of their notification to showcase the directives. Acceptance for the hearing must be written with the sign with the chief executive officer or institution. Upon the receipt of acceptance for the hearing, the council will notify the institution of the procedure of the file prior to the hearing. The institution shall have the right to respond with the evidence fact concerning the areas of the non-compliance with which OL has been charged with the reason the responsible question to present evidence for the opposition to extensional charge of the non-compliance. Such written evidence must be submitted the day of the prescribed by the council unless the institution can show that such information was not available before the submission date, but the failure to make of the timely submission was outside the institutional control. In the event of the council allowed for the hearing of the person with the institution may present with the evidence not and always already considered with the institution may send one or more of the representatives, including legal or financial counsel, to present argumentated in opposition to extenuating of the council action. The council the transcribes all hearings and other records, copy of the transcripts available to the institution upon request. 23501 hearing formats. Hearing formats. Hearing before the council resulting in the showcase directive involving the areas non-compliance to other than additional financial concerns will take place in the panel of commissioners. A hearing panel with at least 3 commissioners will be designated by the council to hear the presentation of the institution. The panel will present the findings of the recommended action. The full council will make the final decision within the time frame specified in Title 2, Chapter 3. Section 23502 Financial Hearings. All hearings before the council with the financial concern only will be heard with the panel with at least 3 commissioners, which will include at least 1 representative of the Financial Review Committee. The panel represents the finding of the recommended action of the full council, which make the final decision within the time frame specified in Title 2, Chapter 3. 23600 Review Board of Appeal Process. For the institution plea to the Review Board of Appeals denial action described in section 23301 and 23304. The suspension action described in section 23402 and 23404. The council established the procedure designed to provide the due process. 23601 Purpose of authority for the Review Board of Appeal for the separate independent appeal for the body established by the council for the purpose of the hearing of appeals by institution for action specified in section 23301, 23304, and 23402. The 23602 appointment of members of the Review Board of Appeals shall consist of the 15%, all of they which have an experience with accreditation, who are appointed with a 3-year term with the person appointed but shall not have the commissioner within 1 year of the appointment of the Review Board of Appeals should consist of at least 2 academic representatives, 2 administrative representatives, 3 public members as defined in Appendix A. Review Board Appeals panel with a 3 or 7 person, depending on the scope of the complexity of the matter with the institution being reviewed, will designated by the council for the entire review board to enter to hear an appeal for the institution. The council will be designated with a member of the review board panel to serve as the chair with the selection action with the panel with the subject. The Accreditation Council, independent colleges and schools, conflicting interests of the policy of the review board panel will consist of at least 1 public, 1 administrative, 1 academic representative defined in Appendix A. 23603 Jurisdiction of the Authority. The Review Board of Appeals is empowered to review upon notice of the appeal at the time file the action specified in section 23301, 23304, and 23402. The Review Board panel has the authority to affirm the decision of the council, amend the decision of the council, reverse the decision of the council, and remand the case for the council recommendation for further consideration. The Review Board may be amended with the reverse decision with the council remain with the call for the council for the further consideration only to find the decision to be only following. One of the following: A. Arbitrary, capricious, or otherwise substantial disregard for the accreditation criteria. B. Non-supportive of the substantial evidence and record of which the council takes negative action. The review board panel cannot amend or reverse the decision of the council remand decision based on an argumentated by appellant that is the council action with disproportional with the violation side. But the review board panel is further limited that has no jurisdiction or authority concerned with the reasonableness of the accreditation criteria. The determination of the review board panel is to confirm the council's decision effective immediately upon review board's panel action, and determination by the review board panel to amend, reverse, and remand the council's decision will refer to the council and implementation further action. Except as noted below, the review board panels will not be considered as evidence that is not in record before the council. Documentation review of the available evaluation team are not considered to be part of the record in life of the appended with the team report. Institutions submit them to the council as part of the institution response to the evaluation team report. Exemption to policy evidence will be made with the final adverse action based solely with the failure of the institution to comply with the standard financial stability. In that case, the institution on one occasion may be seek with a review of the significant financial information with unavailable to the institution prior to determination versus action that bears materially on the financial deficiency identified with the council. The financial review committee will determine its new financial information submitted with the institution significant material if the criteria are met with the financial review committee will provide with the report with the review of the council, which will be reconsidered with the adverse action limited with new information. If the council reaffirms the adverse action, the financial review committee report resolved with the council, the recommendation will become part of the record under the review board with the review board. Panel acts on the behalf of the entire review board. Therefore, the decision of the review board panel is final with not considered further than the full review board. In case of reprimanding the council for the reconsideration, the review board will identify specific issues that the council must address. With respect to the review board, the panel decision implemented remanded with the council. The council will act in the manner consistent with the review board panel decision instructions. 23604 Request for appeals. The exercise of the right of appeal, the institution must file with the request for the hearing before the Review Bureau of Appeals within the time frame determined by the council, normally not more than 10 days. Date of the recipient notification denial of the suspension action. The request for the hearing must be written with the signed with the chief executive officer of the institution. Upon receipt of the request for the hearing, the council will notify the institution procedure for the filing. Preparing it for it. 23605 Hearing of the appeal. A hearing will be held at the time of the place designated by the chair of the review board with the members of the constitute the quorum with implying with the institution intent with the written appeal with the brief with the statement and with the point and must be received with the review of the board panel and the council at least 15 business days prior to the hearing date. The council reply with the brief must receive the panel with the appealing the institution at least 7 business days prior to the hearing. Review board panel chair will be presided with the hearing will rule that all procedural matter there will be no right to cross-examine the opposing parties or its representatives. The council will transcribe all review board hearings for its own records. A copy of the transcripts available to its own institution upon request. Hearings shall be informal, but as many of the reasonable appropriate under the circumstances, both the council and the administration institution appear with or the council with the other representative of the institution may waive the personal appearance, in which the case of the matter will be handled solely on solely on the briefs. The chair of the review board panel will promulgate such additional rule with procedure for scheduling and conducting hearings consistent with these procedures. 23606 Decision with the review board. Every decision must have the concurrence of the major majority of the review board panel. With responsibility timely the conclusion of the hearing panel shall issue for the writing of the decision, same with the reason recommendation, if any, the council of the council. The decision will indicate that the members of the review board panel will concur with the decision. Dissenting opinions may be felt with the majority decisions. Dissenting opinions, if any, of the furnished institution. 23607 Council reports with the review board decisions of the review board panel are transmitted to council disposition publication. Review board panel affirmed the prior decision with the council. There is no further remedy available within these procedures. The council decision immediately in publication automatically. If the review board of the panel remains the matter of the case shall be deemed finally disposed when the council takes final action and reprimanded. 23608 Expenses of the appeal hearing. The institution shall bear the following expenses in connection with the appeal: travel substances to the review board panel participating in the hearing, cost of the hearing room, and the transcription. An appeals deposit must be made with the council at the time of the filing of the notice of appeals described in section 23604. The deposit shall be applied with expense listed above. Any excess deposit will be returned to the institution. 23700 compliance with adverse information procedurally appropriate the council action thereto described and explained with the accreditation council independent colleges and schools received the obligated with investigating legitimate complaints about the institution for any with the sort of any with the way pertaining with the accreditation independent college schools and criteria. Also the accreditation independent college schools periodic received made investigation information federal state and agency other accreditation agency thoroughly public and media sources which may indicate the possibility criteria of violation of adverse information may include but not limited to the low completion rates, low placement rates, and high default rates of the tuition refunded with the improper problems, negative audit of the program, review of the governmental agency investigations. When staff of the accredited council of independent colleges and schools delegated authority to do so determines the complaint with adverse information with the warrant investigation notified with the chief executive officer of the institution writing about the complaint. Adverse information, a copy of the information will be provided. The institution's request to submit the compliance to the council office with the version of the condition of the circumstances which led to the complaint with adverse information. The complaint will be informed of the writing with the institution has been contacted that has been requested, provided with the information on any governmental agency, provided with the adverse information for the council may be informed of the discretion of the council for the action term of the taking the adverse information. The role of the council to resolve the complaint with the investigation verse for the information to determine whether the institution is out of compliance with one or more of the accrediting standards which was the compliant with the address to the which the verse information applies. After such determination, accreditation college independent accreditation council with the independent colleges and schools may then be done with the following: dismiss the complaint, terminate the further investigation versus information. B, postpone a final action complaint whether the adverse information that is evidence that the institution making the progress to rectify the situation or more the investigating is necessary. C, notify the institution on the basis of the information available. Accreditation council independent college school determined that no institution failing to comply with the accreditation criteria for the institution is 1, issued a compliance warning. 2, directive to showcase the accreditation should not be suspended. The accreditation should not be suspended, revoked, or otherwise conditioned. 3, directed to submit the report of the accreditation council independent college schools detailing the plans for rectifying the error to noncompliance. Or 4, direct to undergo the special on-site visit evaluation. The council will inform the complaint with a determination for the council disposition of the complaint. Alright, 23800 special in fact visits. The council reserves the right to initiate special on-site evaluation visits for the request for the specific reports of the institution anytime, both of which were completed under the conditions which within the time frame determined by the accreditation council independent colleges and schools. Refusal institution in response to corporate with such request that should be grounded with suspension for the grant accreditation. At any time the accreditation independent college schools has substantial evidence and information for the institution for jeopardy of the having eligibility with the staff of the federal state agency, accreditation staff and another accreditation agency condition with the accreditation council independent accreditation independent colleges and schools may direct special on-site evaluation visit with the insight with the purpose of the visit will ensure that the students of the institution are not being harmed educationally because of the institution alleged non-compliance with the federal, state, and regulations and other accreditation agency standards and criteria. The council may also direct the FAST assessment compliance team or FACT to visit the investigating report on the alleged improper practice of the accreditation council independent colleges and schools and institutions. The council retains the determination side of the composition special FAST assessment compliance team. Team's length with the Bradif evaluation, making the decision of the council will consider the issue of the factors that promoted the visit with the side of the institution nature of the institution offerings. 23900 debarment. The council may bar a person with including spouse with a closely related family group. This is defined in section 22401 for being owner of the senior administrative governing board of the member of the accreditation council, independent college, school, accredited institution. If the person was found guilty of fraudulent criminal behavior was debarred by a government agency, accreditation agency, as an owner or senior administrative governing board, a member of the institution lost the accreditation, result of the denial, suspension, action closed, or that closed without providing the teach-out refund for the student matriculating the time of closure. Council will notify the person and entity with the intent to be to bar as a result of the denial of suspension action within 4 months following loss of institution accreditation. It will notify the person and entity whom it intends to bar as a result of closing the institution within the responsible period of the time following the closure. In each case, the council will forward the intent of the bar notice both electronic certified mail to the last institutional mailing address known to the council, unless the council has received the updated mailing information following the institutional closure of the lost accreditation. The individual's entities will be considered notified with the council and forward the intent of the bar notice of the accredited accordance with the procedure. The intent of the bar notice to inform the person of the entity that they are entitled to present information with the materials in writing of the person to appeal. The intent of the bar not scheduling the Meeting with the council with the notice of the stipulate that they intend to appeal with the intent of the bar with the expressed entity must inform the council office writing within 10 days of the receipt of the notice whether they will appeal intent with the bar of the writing or person. The debarment order may be issued with the council as a result in consideration of the fact presented with the council's decision will be sent to the person in either the electronically certified mail following the appeal before the council. Council decision final of the person that elects and not appeal with the 10 days council notification. Council decision also following appeal. The council retains the final discretion. Establish terms, length of the department. The length of the department will be a period of at least 3 years. However, they may vary depending on the circumstance of the department decision. Individual circumstances must justify a longer period of debarment. Alright, Title 3, Evaluation Standards, Chapter 1, General Standards applicable to all institutions.